Adjournment request, if any, from item number 1 to 5. From item number 6 to 16, adjournment request. From item number 17 to 26.
Wait, please, your lordships. My lords, with the consent of the other parties, my lords, I beg to mention item number 23, my lords.
23.
23, yes, my lords.
Okay, adjourn.
Deeply obliged.
Lordship, matter fix on 9th or 10th, Lordship, June.
My lord,
Obliged.
Deeply obliged.
lordship, in item number 21, my lord, I prefer 2 weeks' time. Here, I am required to file the rejoinder to the reply.
When the council appearing for the respondents, respondent state there is some more time to find affidavit in opposition.
Affidavit we have filed, my lord. I'll file a rejoinder to their reply.
Counter to the reply filed on behalf of or on behalf of whom?
For the respondent. For the respondent, we have filed the affidavit of opposition. They have filed a reply denying our stand.
When council appearing for the state place some time to file counter affidavit. Who the affidavit filed on behalf of the petitioners.
May I please, your lordship.
Yes.
Lordship, I beg to mention item number 19 and 20 for adjournment, Lordship. My senior counsel is out of station. I've also presented a leave application as well.
Adjourn, August.
Obliged.
Please, your lordship. My lord, I beg to mention item number 22, my lord, with due consent.
20?
22, item 22, my lord, I beg to mention.
Yes,
My lord, I seek an adjournment, will like to file a reply. I'm for the respond number 12.
you are for the respondent.
12.
Okay, then council appearing for the respondent number two place for list in the month of August.
Deeply obliged.
Yes,
Any other request?
with no objection, other side.
Daily list for orders item 1.
Or affidavit from Vice.
My lord, to be honest, if they feel nothing has improved, same thing is continuing. They are filing affidavits, art cutting is going on. Lord, flowery languages are being used, filing affidavits.
Art cutting in relation to that.
No, my lord, it has not stopped.
No, but they have filed an affidavit.
It appears they have taken some steps, my lord,
Yes,
but it has to be implemented.
so how it is not implemented?
It's not, my lord.
They all.
We can just find out in Guwahati, so many sites, my lord, we see the arts are being filled with red earth. Where from it comes? It comes from the hills. And now, my lord, river sand is not available.
That's right, but if one order, they have issued that in in the affidavit.
Yes, in the recent affidavit, they have, my lord, if the measures are taken is well and good.
That they have mentioned.
Hmm.
That measures taken by the area with maximum instances of getting observed falls in so and so.
No, my lord,
It's a
these
problem.
regulations are there since 2022.
They issued an order under section 162 of the Bharatiya Nagarik Suraksha Samhita prohibiting cutting of hillocks.
Yes,
And this at present existing regulations to tackle the problem
yes.
of hill cutting in. Either you show some instances that despite all this, they are not this.
Okay, we'll do that. At the number 1, we'll do that, my lord. And number 2, my lord, they engaged a firm from Netherlands. I understand, my lord, they have submitted the report. By spending 13.5 crore, the suggestion which we have given, this thing only that has been done.
The suggestion.
Yes, so therefore let them place that, my lord. And also place before this honorable court the tender process according to which they have adopted. They say they have adopted a tender competitive bidding process for engaging that foreign firm. My lord, I have information, they have submitted the report. Only
that-
suggestion is, my lord,
That firm which was engaged.
yes, And the suggestion which we have given in our initial response, my lord, that is the,
That's good. If your suggestions are accepted.
no, my
then
lord, at the cost of 13.5 crores.
Sir, that, Mr. Chaudhary, on earlier order, we are simply, this is relation to the tackling, how the government is tackling it. So far as regarding if there is any irregularity in granting tender or something else, you can file separate petition.
Okay, my lord, we file an affidavit pointing out infill, nothing has improved.
Yeah,
Yes,
that
we'll do that. And in fact, my lord, a small spell of rain, Guwahati goes here.
That we will consider.
Only thing is, my lord, they should do something. Let us not take it as an adversarial litigation.
We'll consider.
We are only pointing out how it is the loopholes are to be plugged.
Pursuant to the direction given by this board on 17/3/2025. An affidavit is filed on behalf of the Additional Secretary to the Government of Assam, Department of Housing and Urban Affairs. Wherein the measures taken by the state government to stop the illegal hill cutting have been mentioned. To stop. It is, the affidavit also highlighted the existing regulations to tackle the problem of hill cutting in Guwahati. Full stop. Learned amicus curiae has submitted that though the state government has taken some measures for restraining the illegal hill cutting, but as a matter of fact, the hill cutting is still going on. It is also submitted that the regulations are very much there, but the compliance of the regulations, the strict compliance of the regulations is not reflected from the actions of the authorities of the state government. So top learned council raised some time to highlight the instances, the recent instances of hill cutting in the Guwahati, in the city of Guwahati,
In and around Guwahati city.
in and around Guwahati city. Time plate for is grant, list on, time plate for is granted, full stop. It is also to be noticed that recently on account of rains in Guwahati, the problem of flooding is again the problem of flooding of roads and some of the residential areas has also been reported widely in the newspapers as well as the TV report. Full stop. Learned Advocate General is directed to furnish a detailed report regarding the measures taken by the state, taken by the administration to, in pursuant to the report submitted by the agency which has been hired, for suggesting a plan for tackling the flood situation in the Guwahati city. Full stop. How much time you will?
4 weeks time will be.
Four
I'm
weeks
also
is
saying
much.
for a specific
4
time,
weeks is much.
3 weeks,
2 weeks.
2 weeks, no.
We'll also file within
This-
2 weeks.
Yes.
I'm also paying
This,
for
this
direction
matter
from-
after 2 weeks. Yes.
I'm paying for direction from this honorable to the respective deputy commissioner and respective frontal officers to keep a watch on the hill.
On the hill cutting.
Yes.
You, sir, that is
That observations will help us.
why.
In fact, it is already there. These regulations, everything are there for lots of.
Mr. Sekia, if they are not following, if they are not following the regulations or guidelines, it is for the state to act. Why they, why they direct-
Observation will help us.
we have already, this clarified it. That they are raising that they are not following this.
But now they are very strictly monitoring still. Sometimes some +%
List
will-
after, list after 2 weeks. So they.
Deep privilege.
11/6. Item number 2.
Respondent number 1 and 2 has not been served.
Your lordship, I may be allowed to take Dusty, your lordship.
Linkage. as per the office report, the notice is issued to the respondent number 1 and 2 is not being served, sent through registered post with AD. Stop Learned Counsel appearing for the applicants to take some time to take fresh steps for service of notice upon the respondent number 1 and 2 to the scheme mode. To stop bank rate for is granted, requisites for service of notice upon the respondent number 1 and 2 for the service be be completed within a period, be furnished within a period of 1 week.
Yes, sir.
On furnishing the same, let notices be issued to the respondent number 1 and 2 for the service.
Item number 3.
Yeah,
Four-
Mother,
4 and 5 has not been served, sir.
no, my lord, as per Lojima code report dated 8/5/25 has been served.
Completed. Okay.
Yes, ma'am, completed.
Yes, you are a bit
1 and 1, 2, 3.
1, 2, 3. Okay, as per the Lozima court report. The notices, unserved notices to the respondent number 4 and 5 has been duly served. Full stop. In such how many days delay is there?
Release, my lord, 50 days, delay, my lord.
51 days.
Yes,
Yes, do you have any? No. Full stop. The matter comes upon for consideration of the IA number so and so with a prayer to condone the delay of 51 days in filing the connected rate appeal. Having the learned counsel appealing for the respondent number 1 and 3, 1 to 3 has no objection. If the delay is condoned, having heard the learned counsel for the parties and after going through the contents of the application, we deem it appropriate to condone the delay and IA is allowed, delay of 51 days is condoned.
published.
Item 4.
On the number 1 and 4 not served.
Two and three appears.
2 and 3 appeared, you know.
2 and 3 served.
My lord, I
One and-
appear for 2 and 3.
What about the 1 and 4? Await correct? Await return of notices of respondent number 1 and 4. 4. 3
Like-
more weeks.
Item 5.
Mayor, please.
3 and 6.
Yes,
You are approved?
yes.
For whom?
State Bank of India, that is CPPC and the branch.
3 and 6.
Yes.
Who are 3 and 6?
The Assistant General Manager is CPC
Pension.
pension,
And
and 6 is the branch where the account is maintained.
6 is the bank.
Yes,
For both of you, you
for
are,
both of both.
how you are justifying this deduction?
Well, Lordship, in the month of December 2024,
Yeah.
audit was taken up
What audit?
by the respondent number 2.
Ah,
And there they have flag marked that excess amount has been paid because the State Bank
how
is
this
the,
excess amount? How you are calculating this excess amount?
that is, that is, they have calculated. We did not.
You are for the respondent number 2? So how you are, Hey, what do you mean by, how can you club this High Court pension with the CAT pension? That is already settled. That is already settled. Up to Supreme Court. You can't club it. The altogether dependent, you can't club these both the services. By what time?
No, no,
Which
we have,
extra
we have, we have. Yes, served. Huh? Two served. Huh. We have given the affidavit also. We have given the affidavit. Huh.
This is unacceptable. By what time you will file your response?
2 weeks, Your
Not 2 weeks. Within a period of 1 week.
Lordship.
And either you argue the matter finally or otherwise we are going,
Lordship.
we are going
Yeah, we
to pass an order for refunding the,
Lordship.
you can't do that.
Lordship.
Okay. Mr. So and so put an appearance on behalf of the respondent number 1, 2, and 3. You are Mr. Chakravarti. 1 and 2, and who is the 3?
3 and 6.
Mr. Chakravarti put an appearance on behalf of the respondent number 1 and Mr.
Yes, Datta.
So and so is appearing on behalf of the respondent number 3 and 6.
Right.
Stop. Mehta, you are appealing for? 7. 7. And who is appealing for registrar? This respondent number 4. Mr. So and so is appearing for respondent number 4. Who is appearing for this CAT? Central Administrative Tribunal. Normally who appears? Notices have already been served in the writ petition?
Yes.
In the writ petition, notices have already been served to all the persons.
All the person, yes,
respondents.
yes.
Nobody is
Notices have been
on behalf of the respondent number.
key number that. 7, 8.
Respondent number 5 and 8. Full stop. As a matter of fact, the
We have filed an affidavit
petitioner has
also.
not raised,
Service.
prayed any relief against the respondents. 5, 8, and 7, and has only prayed relief against the remaining respondents. And therefore, the requirement of service upon the respondent number, a requirement of service of notice upon the respondent number 5 and 8 is at
I will
present
make-
waived in the IA number 1563 as well as in writ petition number 2531 of 2021.
25 and 8.
The matter pertaining to reduction of rupees 57 lakhs from the bank account of
5 and 8.
applicant on the ground that he is in receipt of excess payment of the said amount in his against his pension. Full stop. The petitioner, the applicant was applicant is a retired High Court judge and has also served as Vice Chairman of the Central Administrative Tribunal, Guwahati. The respondents have acted under the presumption that the petitioner cannot get pension in both the pension for both the services, that is as a High Court judge and Vice Chairman of the tribunal, CAT, and therefore CAT, and as such, they have clubbed both the services. Full stop. Prima facie, we are of the view that the action of the respondent, of the contesting respondents is not in accordance with law. The matter is already settled up to the Honorable Supreme Court. See, Union of India versus Pratibha Banerjee and another reported in 1995, 6 SCC 765. Union of India versus KB Khare and others, 1994 supplementary 3 SCC 502. Justice P. Venu Gopal versus Union of India and others reported in AIR 2000, Supreme Court 3887. And decision passed by the Karnataka High Court. A single bench of Karnataka High Court in writ petition number 16604 of the 209A or either in Paskin K. Balakrishnan Nair versus Union of India reported in 2020 Supreme Kerala 153. Full stop. Learned counsel appearing for the contesting respondents number 1, 2, 3, 1, 2, 3, 4. No, 1, 2, 3. One, two, three, and 6. And directed to 5. Counter to the IA number so and so, as well as the writ petition by the next date of hearing. This one.
2 weeks. 1 week.
6th of June.
6th of June.
Clubbing, your lordship may have already given, but 94 supplement 3 SCC also.
Which is that?
That is Union of India versus KB Khare.
That I already.
Yeah, did you?
Item 6.
Number
57 days.
57 days.
57 days. Delay.
Delay, my lord, it's 57 days, my lord.
Is that a merit?
My lord, on merits, my case is, my lord, the petition,
You have wrongly mentioned the roll number.
no, my lord, I'll just explain, my lord, what happened.
Of the learned single judges.
Yes,
Yes, Learned Single Judge has said that there was no discrepancy in the, or
After going through the original launch.
Yes, that is what is before this court.
I understand, my lord, I have also seen that. My lord, my case is that in the first attempt, the petitioner cleared the preliminary examination 2 paper. Then, my lord, main 6 papers he appeared and he cleared. Now he was called for viva voce. Now the QCA, first page of the QCA booklet, which was furnished to the petitioner by virtue of the RTI application, my lord. Lord, a bare look of that particular document will lead to a conclusion that there was some infirmity in that. Because I'll just,
Infirmity of what?
the handwriting pattern in that, I'll just explain.
You have not, raised allegation against of malified any against a person.
No, there is no-
that, somebody has changed my roll number or something when the original itself was seen by the learned single judge. Stop in that.
Lord,
You have mentioned wrong number, roll number.
my lord will kindly have that document once.
My lord, no problem. Even tomorrow I can.
Did they confirm the fact?
My lord.
Having heard the matter comes upon for consideration, otherwise I don't think so there is.
No, I'll try, my lord, I'll try to satisfy, because there is
Matter
another
comes upon
limbo,
for
my
consideration
argument.
Of the E number so and so with the prayer to condone the delay of the 57 days in filing the connected letter. The next council appearing for the respondent, there is no objection if the delay is condoned. Having heard the non-responsive for the parties and after going through the content of the application, we are of the view that delays, the delay in 57 days in filing to and so, IA is allowed. The registry is directed to connect writ appeal and just after 3 weeks.
My-
Register after registering 3 weeks.
Much obliged, highly obliged.
For admission, item 7.
Already been similarly situated, my lord, appeal is already admitted, my lord. This is already fixed on 10th of
It
June.
is already-
Some similar matter, my lord. The appeal is admitted, my lord, and fixed on, my lord, 10th of June, my lord. It's regarding the, my lord,
Same matter,
yes, my lord, 34 and 28 interest, my lord, of the Acquisition Act, my lord.
the
Section 28 and 34 interest, my lord. This,
that is similar matter
yes, my lord.
against the same judgment or
My
judgment?
lord, different judgment.
Yes, Lordship.
ठीक है, let me consider looking for the evening of India. Yes. Submitted. A similar order, a similar order passed by the learned, by a single bench in land acquisition matter was challenged before. This court by way of appeal number 320/2023. And this court is pleased to admit that this appeal and has also passed the next stay order and list the stay order. The copy of the order is 22/5/2024. Passed in writ appeal number 320/2023 is pressed into service. So, in view of the above, admit, issue notice,
I am for respondent number 1 and 2.
Ms. So is appearing on behalf of the respondent number 1 and 2, let notices be issued to the other respondents, returnable 6 weeks through registered AD and Dasti. After service of notice upon the respondent, tag this writ appeal along with 320/2023. In the meantime, effect and operation of the order dated
My lord, this order at
2024 passed in writ appeal, writ petition number 23/2023.
and subsequent assessment of the DC, my lord.
23 shall remain stay. Subsequent
Assessment of the DC.
direction, the direction is to this determine and then disperse. We are staying it for all purposes. Stay. Yes.
Item 8.
May it pleases your lordship, my lord, this is an great appeal against the impugned judgment and order dated 10/10/23, my lord, whereby the learned single judge has set aside the recovery notice dated 25/2/2022, my lord. My lord, the impugned judgment, the relevant part of the impugned judgment is at page 115, my lord. Para 10, my lord, 10 onwards. May I read it, my lord? When in view of the aforesaid principles of law, the impugned notice dated 19/4/2022 is considered, it is found that the decision conveyed by the impugned notice was not without any prior opportunity of hearing to the petitioner or prior consent of the petitioner. It is also found that the respondent FCI by its decision contained in notice dated 19/4/2022 has contemplated to recover an amount of rupees 12,60,298 from the petitioner's bills, security deposit, bank guarantee, etc. And such recovery has been sought to be done in a completely unilateral manner without any consent from the contractual party. My lord, the facts of the case is that as per the NIT, my lord, in the NIT, the distance to be covered was written as 30 kilometer, whereas in the actual distance was 8
Here,
kilometer.
Mr. Please here issue notice.
My lord, notice may be issued at this stage.
Yes, we are issuing notices. They are already issued.
I think notice has not been issued, my lord. It has been listed for the first time, my lord.
Returnable 4 weeks. AD, registered AD in Dusty.
Item number 9.
Highly obliged.
Lordship, I want to place on you because the two direction was given, Lordship. Respondent number 2, although Lordship, it was observed in page 130,
Read
paragraph 18, paragraph 18,
paragraph 15.
page 103,
Yeah.
130. The
Yes.
respondent number 4 being not at fault for the said appointment and as.
Where is that? Where is that? Para number
18, 18,
18.
lots, page 130.
Yes, at this stage.
The respondent number 4 being not at fault for the said appointment as affected in this case. This court, after lapse of such considerable period of time, would not like to interfere with the appointment so made in respect of respondent number 4. Although the same was in violation of direction passed by this court by order dated 2/6/2015. In petition number so and so, which is which in effect has continued the service of the petition in Tezpur University. Now, Lordship, page 131, last paragraph.
131.
Lordship. Subpara 6.
Para?
Subpara 6.
Yeah.
Given the facts, the circumstances involved in the matter, on resumption of her service by the petitioner, she would not be entitled to any arrear pay and allowance. However, the pay and allowance of the petitioner shall notionally calculated from 22/3/2014 till date she is allowed to resume her service. And basing on the notional calculations from it, also including therein, the revision of pay that may have occasion in the meanwhile, fix the pay of the petitioner in the post of public relation officer and or any other equivalent post or supernumerary post created for the purpose. Lordship, for creation of supernumerary post, Lordship, for the university, because it is a central university. And without the direction of the UGC, that cannot be done. Lordship, I am relying on 3 authorities, Lordship, may kindly.
They're relying the direction of the university. What do you mean they're relying the direction to the UGC? You apply to the UGC?
No, we have applied, they have suggested to approach this honorable court under his jurisdiction. Lordship, I am relying on 3 judgments.
Sir, which judgments 3? The facts of the case are.
Lordship,
What are
here,
the facts?
no, Lordship,
In 2014, she was removed.
Yes,
In
Lordship.
2015, court has issued direction to they set aside that. You have not reinstated her.
no, Lordship, we are not.
And now you have initiated another advertisement. You have selected one person.
Yes, he was
Then
appointed.
what's wrong in this order?
Lordship, Lordship, honorable single judge observed that his appointment was not as per law.
No. He
Yes, sir.
simply said in violation of the direction.
Violation of the direction passed by.
There is no such declaration that his appointment was illegal.
No, Lordship, when it is in violation of the court's order and he was allowed to continue. And
That is your fault. Why this person should suffer for that?
No, Lordship, Lordship,
That
Supreme.
was your fault. Despite stay order, you continued with this election, you appointed him. And now you are saying his appointment was illegal. How
No,
can you say?
Lordship, in that petition, there was no stay order, Lordship.
No stay order, then it's okay, fine. Otherwise also, this lady is supposed to be
no,
reinstated in the year 2015 itself.
Lordship, Regarding that lady, Lordship, we have no grievance, Lordship. She
So
will be
what
appointed.
grievance now you
No,
have?
Lordship, we are given to create a supernumerary post.
Yes,
That is not permissible in law also.
that is not permissible. Don't create, adjust her any other post.
Lordship, that is-
Similarly, the court has simply given a direction.
Yes, Lordship.
What direction? Allowed to resume her services fix and on any other equivalent post
Post
or a superannuation
superannuation
post.
post.
Don't create, adjust her at as equivalent post.
Lordship, that is the problem in university. Lordship, there is no extra post to.
That is your problem and your headache. The direction is not, we don't find any illegality in these.
No, Lordship, I'm not on that. Lordship, may please to consider 3 authorities.
Which authorities?
Lordship, I'm placing.
Absolutely high-handedness on your part.
No, Lordship,
Can you, 2014, her termination, 15, her termination was set aside.
yes, Lordship, we are,
Despite that, you have not reinstated her, continued with
no,
the
Lordship,
further
what
selection.
happened in the,
And, she was supposed to,
she was on probation, so if probation was cancelled and she was again terminated.
the, sorry. And that's why only the learned single judge has kept it open. That you can initiate
Yes,
a
Lordship.
disciplinary, you can remove her,
Lordship,
but not. in this
regarding
manner.
creation of supernumerary post, Lordship, paragraph 15 of that divisional manager Aravali Golf Club,
Para number
15 Lordship.
15, read.
The court cannot direct creation of post. Creation of post, sanction of post is a prerogative of the executive or legislative authorities. And the court cannot arrogate to itself this purely executive or legislative function and
Page
direct,
number, which page?
let's say paragraph 15. That is 2000,
15, page number
page number 3, Lords.
3.
Lords. The case title is divisional manager Aravali Golf Club,
Page. So this is.
paragraph 15.
3.
So this is 2008 1 SCC page 683. Divisional manager,
Just. The court cannot direct creation of post, creation of.
Yes,
creation
sir.
of post. Okay, fine. There is no direction of creation of post.
no, Lordship, because there is no post and court is directed to create a supernumerary.
Or.
Yes, Lordship.
Simply, they've given you the option, there
Yes,
is no
Lordship.
direction.
But Lordship, and we immediately, and another two judgments on the same line, Lordship.
Yeah, read.
The Lordship, this is 2009, paragraph 27, 29 and 30.
2009, this,
Paragraph-
Maharashtra State,
Paragraph 27, Lord.
paragraph 27.
27, 29 and 30. Page 12.
Yes,
There cannot be any quarrel to the proposition that the court cannot direct creation of post in Mahatma Gandhi Phule so and so, so and so. Lordship,
and another is last.
last is 2023 0 Supreme, paragraph 47 and 48. Same proposition has been dictated. This earlier judgment has been protected. Paragraph
That's all?
47. Yes, ma'am.
This, you have what? This needs appeal is. filed like this. Appeal answering agreed with the order dated 9/1/2020 Learned single judge in the petitions number 2561 of the 2016 and 4770 of the 2015. The defects of the case are. The private respondent. Applied pursuant to the advertisement number 1/2012 issued by the 1/2012 dated 5/1/2012 issued by the Registrar Tezpur University inviting application for the post of Public Relation and Information Officer in bracket PRIO. Full stop. The private respondent being successful in selection was appointed as public relation, as PRIO of Tezpur University. Full stop. Our initial appointment was on ad hoc basis for a period of 2 years against a permanent post. And the said period was treated as a period spent on probation. Full stop. The period of probation was extended up to 22/3/2014. However, in the meantime, the services of the private respondent were terminated on 13/12/2013 by the Tezpur University. the private respondent has assailed the said termination order by filing writ petition number 7526/2013. However, during the pendency of the said writ petition, the Tezpur University has withdrawn the said termination order dated 13/12/2013. And looking to and taking into consideration the same, the writ petition number 7526/2013 was closed. Full stop. On one hand, withdrawing the order dated, we're withdrawing the termination order of the respondent on 20th of March 2014. On one hand, the Tezpur University has withdrawn the termination order dated 13/12/2013 of the private respondent, while the order dated 20th of March 2013. However, on 21/3/2014, they passed a fresh order and released the petitioner from the services of the university, that is from 23rd of March 2014, on the ground that the term of ad hoc appointment of 2 years was completed. Being agreed with the same, the private respondent has preferred writ petition number 1734/2014. And a single bench of this court has disposed of the said writ petition by the order dated 2/6/2015, wherein the termination order dated 21/3/2014 was interfered, and the same was set aside.
Yes, my lord.
The same interfered and the same was set aside. Full stop. It is to be noticed that the Tezpur University has not challenged the said order dated 2/6, has not challenged the order dated 2/6/2015, passed in writ petition number 1734/2014. But has not permitted the private respondent to resume her services and went on to issue an advertisement number 4/2016, dated 23/3/2016, inviting applications for filling the post of PRIO in the Tezpur University. The being agreed with the same, the appellant, the private respondent has filed another writ petition. Has another writ petition number
2561, my lord.
2561
61 of 2016.
of 2016, challenging the said process. In the meantime, the respondent Tezpur University has appointed the respondent number 4 of the writ petition as PRIO in the PRIO in pursuant to the advertisement number 4/2016. Taking into consideration the facts and circumstances of the case, the learned single judge has allowed the writ petition and issued certain directions. The relevant portion of the impugned judgment is reproduced here on para number 10 say impugned judgment the last one. Full stop. Learned counsel appearing for the appellants has assailed the impugned order on the ground that though the learned single judge has specifically observed that the respondent number, the appointment and selection of the respondent number 4 on the post of PRIO pursuant to the advertisement number 4/2016 is in violation of the order and directions passed by this court on 2/6/2015 in writ petition number 1734/2014. However, the learned single judge has refused to interfere with the appointment and selection of the respondent number 4, which is illegal. Learned counsel has further argued that the learned single judge in the operative portion of the in the direction number Roman 6 has directed to create a supernumerary post for the purpose of adjusting the private respondent as public relation as PRIO. Stop relying on the learned counsel has placed reliance on the decision of the Honorable Supreme Court rendered in this so and so and ये 3 judgments and has argued that the position of law is very clear and no direction can be given for creating a supernumerary post by and the court cannot issue any direction for creating a supernumerary post. Full stop. We have heard the learned counsel for the parties. Heard learned counsel for the parties. Stop. We are of the view that the learned single judge has rightly not interfered with the appointment of the respondent number 4 of the writ petition on the post of PRIO pursuant to the advertisement number 4/2016 because the respondent number 4 cannot be said to be at fault for such appointment. Full stop. The respondent university, despite cancellation of the termination order, despite setting aside of the termination order of the private respondent with petitioner, has continued with the selection. And for that, the respondent, the person who was appointed as PRIO pursuant to the advertisement number 4/2016 can't be penalized. Full stop. So far as regarding the contention of the learned counsel for the appellant that the court cannot direct for creation of any superannuity post, we are of the view that as a matter of fact, the learned single judge has not passed any order for creation of superannuity post and has simply suggested that the respondent, that the respondent writ petition, private respondent writ petitioner be adjusted either or any equivalent post or available or a annuitary post created for the purpose by the university. Full stop. Such suggestion cannot be termed as a direction, and as such, we don't find any merit in this. Let appeal the same is therefore dismissed.
Much up.
My lord,
With
the
the
first-
first of the parties, matter is heard finally shroom. The consent of the.
My lord, the first order of termination was withdrawn on 12/3. Your lordship had dictated it to be 23.
20th of March.
20th of March was the order of the honorable court when the matter was withdrawn. The order was withdrawn by Tezpur University on 12/3.
12/3.
12/3, my lord. 23 was the order of the court.
12.
I'm grateful, my lord.
Item 10.
Please, your lordship. Lordship, I ought to have been fined before the DRT lordship, but the PO is on leave lordship. The
So what else?
Siliguri PO is in charge, your lordship.
In that situation, huh?
Siliguri PO is in charge.
Maybe you have to approach the DI. Simply because he is on leave. Tomorrow, if there's some of us from leave, then you will approach the Supreme Court. Since the judge is on leave, therefore,
No.
that can. Go to DI. Withdrawn with liberty.
Would liberty to approach the.
After attempting to argue the matter for quite some time, learned counsel, the petitioner on instruction has submitted that he wants to withdraw this writ petition with liberty to approach the DRT. Against the auction notice,
Sorry, lordship?
against the auction
Yes,
notice.
sale notice, lordship.
Sale notice and notice. Against the sale notice issued by the respondent bank
Page 18, lordship.
while exercising the powers under the SAFESI Act, dismissed with liberty of state power.
Item 11.
Please, your lordship. Madam, before I go into the matter, I would like to put one fact that already I have been compulsorily retired, which I have been put to challenge in earlier writ petition. Your lordship has fixed the matter after 2 weeks. So the matter is coming up, I believe, on Wednesday. Yes, sir. Now here what happened is that the issue is that a simple issue is that after I was being given compulsorily retired, which is put to challenge, the respondents, they issued 2 notices to me. One was dated 7 April 2025,
Where is that notice?
annexure P1, my lord,
Annexure P1.
P1.
Page number
Page number, it will be, your lordship, 15,
15. Yes.
15. By this order, the respondent number 4 informed to me that our inquiry officer has been appointed. Now, subsequently, a second letter was issued to me by the inquiry officer that as far as the Nagaland Discipline Service and Appeals Rule, inquiry will be conducted against me. I wrote a letter to them that under what authority you are giving me this letter?
Why?
Because my lord will appreciate the service rule does not provide that a departmental inquiry can be proceeded once I have retired from the service.
So when the department inquiry was proceeded against you or initiated against you?
My lord, the first and foremost thing is that yes, it is a fact that departmental inquiry will proceed once the charge sheet has been given.
Right.
Yes. Now question is that can a departmental proceeding or inquiry be initiated once the officer has been retired?
Initiation of the departmental proceedings
My lord.
is with the issuance of the charge sheet.
My lord,
When the charge sheet was issued,
no, charge sheet was not issued to me,
not at all.
not at all.
Yes, what is the factual report?
My lord, he has not annexed this document before this honorable.
Which
Yeah, you
document?
Place it on record.
Which document, sir?
My lord, your lordship kindly see, my lord. He was, my lord, statement of allegation. Your lordship kindly, my lord, see the Nagaland, my lord. Nagaland Service Rule 1967.
Yes, I have.
In that, my lord, in pursuance to, my lord, Rule 9,
Yes,
Rule 9(2), your lordship kindly see.
yes.
The departmental authority shall frame a definite charge on the basis of the allegation which the inquiry is proposed to be held. Such charge together with the statement of allegation which they are based shall be communicated in writing to the government servant. And then he shall be required to submit within the such time as may be prescribed in the disciplinary authority in written statement on his defense, and also state where the desire to hire the person stand from the so and so so and so. So accordingly, my lord, statement of allegation, charge, along with the everything, my lord, he has served on 31st of January.
Just a minute.
But that was not annexed with, my lord.
Mr. Mehta, please,
My
give us the dates. What is the date of this compulsory retirement date is
27 March 2025.
27th of March 2025, you were compulsory.
Yes, my lord.
Okay. From which date?
With effect from 31, my lord.
With effect from 31st of March afternoon.
So essentially, you were compulsory retired from 31st of March 2025 afternoon.
Afternoon.
Okay. When this charge sheet was served?
My lord, that was 30th January 2025.
8th of January 2025. So how you can say that initiation of inquiry is?
My lord,
after
your lordship will come to pay. That initially I was being put under suspension. After that, this statement of allegations was put. I replied to that. The departmental inquiry was pending. Now, on 27th of March 2025, I was been asked to go for voluntary compulsory retirement, exercising the power under Rule 20 subclause 2, which has been put to challenge in my
That's another
that is
thing.
there.
separate.
From here-
Second thing is that this order which has been passed, my question is that under what authority you can pass this order? Because once I have retired from service,
What authority the disciplinary proceedings even can be continued?
but where is the legal fiction, my lord? There has to be a legal fiction.
So you just show us that there is. no
Your
legal
lordship,
fiction.
your lordship, I will take you to your service rules. Kindly, I have give.
Mr. It is not under the service rules. It is under the pension rules.
Pension rule, my lord.
It is there.
It is,
If you are not aware of that, we are sorry. It is under the pension rule.
yes, I have three
If
copy.
you
I
are
have
not aware, we are sorry.
very clear.
My lord, your lordship will appreciate this thing. That once I have put
There
on,
is a provision under the pension rule.
Pension.
Where if a person is retired and the inquiry, disciplinary proceedings are pending, they can be continued.
no, your lordship, when my suspension order was been revoked, when my suspension order was revoked,
Rule 27 and something else.
My lord.
my lord, your lordship will appreciate when my suspension order was revoked. That means,
That doesn't mean that the inquiry is over. That was only a
my
suspension.
lord,
order.
I will place two authorities. Your
What
lordship,
authorities, sir, on this? What authorities on this?
your lordship will appreciate these two authorities, your lordship.
Mainly after retirement, no proceedings can be initiated, but here in this case, initiation is with the charge sheet you yourself has submitted.
My lord,
And if the charge sheet is already furnished to you, you have furnished your explanation pursuant to that. Now the only remains that the appointment of inquiry officer. Inquiry officer is appointed.
your lordship will appreciate this fact that the entire thing started from the date of my suspension order. Your lordship will appreciate. The suspension order was subsequently revoked and said,
How it affects? Even though if it is revoked or certainly if you are supposed to compulsory retire, the suspension is to be revoked.
my lord, the question that,
Otherwise, you can't be compulsory retired while in suspension.
no, my lord, you will appreciate this. The suspension will be, when the suspension goes away, when the departmental proceeding was been dropped, that has
I mean,
been,
how can it be dropped? Where is the order of drop?
your lordship, that is raised in the WPC, the other writ petition,
No.
which is coming up on the,
In that matter.
That is
will-
voluntary.
But my lord-
Voluntary.
Mr. I am sorry. What you are arguing? Sorry to say, sir. You yourself are saying initiation of the disciplinary proceedings with the issuance of charge sheet. Charge sheet was issued to you in way back in January 2025. In the meantime, if you have retired even, the disciplinary proceedings can be continued. That is the position of the law.
my lord, there has to be a legal fiction to that.
What legal?
Legal fiction, the service rule has to say that,
Sir, the service rule is not required.
because your lordship will
Pension code
appreciate,
says-
your lordship will appreciate that this is a continuation of the proceedings which has been challenged in the earlier writ petition.
No.
So what I am suggesting,
In the earlier writ petition, you have challenged the decision of this High Court to compulsory retire you.
my lord, that has
from
been
the
challenged.
services.
Yes,
That was not under any disciplinary proceedings.
Yeah, separately.
You were compulsory retired under a different procedure
No,
or different rule.
you draw the proceedings against me under the service rule. Then you give me compulsory retirement under the judicial service rule,
So what
which is non-extant law, my lord.
no law, then we'll consider it. So far as regarding here, you are saying, what is your ground in this petition?
My lord, my ground is that as per the service rule,
Yeah.
when there is no rule which postulates the conduct of a departmental inquiry.
Okay, fine.
My lord, your lordship kindly see, my lord, probably he has not gone for that, my lord. In respect of Nagaland, my lord, there is no service rule, service or pension code, my lord. In respect of Assam, there is a pension rule, my lord.
Fine.
But in there, Nagaland, government of Nagaland following the central civil service pension code, my lord.
Right.
In central civil service pension code clearly mentioned all these things, my lord.
Love. Then
These are the copy, my lord.
That's a copy of it.
Sorry. Rule 8, my lord. Central Civil Service Pension Rule 2021.
yes.
Rule 8, my lord.
Yes.
Sub rule 2.
Yes.
The departmental proceeding referred to the sub rule 1 if instituted while government servant was in service, whether before of his retirement, during his retirement, shall be after the final retirement of the government servant, are deemed to be proceeding under this rule and shall be continued and conducted by the authority by which they will commence as the same manner if the government service and continue in service. Then your lordship kindly see the explanation. My
Yes.
lord, that is, my lord, your lordship will find it, my lord, 8 explanation, my lord, sub clause 8.
Yes.
Explanation. For the purpose of this rule, departmental proceedings shall be deemed to be instituted on the date on which the statement of charge is issued by the government servant for or petitioner or persons or pensioner. So your lordship kindly say departmental proceedings shall be deemed to be instituted on the date on which the statement of charge is issued. My lord,
Your
like
lordship,
my lord, very recent judgment of the Honorable Justice Bhuya, my lord. Clear all these things, my lord. I just place my lord these things. Very good
Naveen
judgment.
Kumar Sinha judgment, which my lord, my senior is going to refer. The lord kindly see annexure P2.
In that
Annexure
para,
P2, page 17. Page 17. As my learned friend, my senior colleague has referred, that in Nagaland, there is no pension rules. They are following that rule.
Central government.
Central. Now, your lordship will kindly see annexure P17.
Yeah.
P2.
P17.
P2, sorry, my lord. Page 17.
Yes.
This is the letter issued by the inquiry officer. Now, with reference to the subject above, I am directed to inform you that the Honorable Guwahati High Court so and so, dated Guwahati 7 April 2025, was pleased to appoint me as the inquiry officer in disciplinary proceeding drawn against you, along with Sri N. Ijung, Principal District and Session Judge Dimapur, has been appointed as the presenting officer for the disciplinary proceeding, and the same letter of communication issued by the registrar enclosed with documents has also endorsed a copy. Your lordship, so disciplinary proceedings against you under the Nagaland Service and Disciplinary Appeals Rule 1967. Now, your lordship, the inquiry which will be conducted under the rule of 1967. There is no issue on that. Now, question arises that the pension, as far as I understand, the pension benefits will be decided to adjudicate the amount, whether you will be given pension or not. Your lordship, that aspect has been dealt in Naveen Kumar Sinha's case, Ujjwal Bhuya, which my learned senior colleague was referring. Kindly see this. Where it was held that if the service rule does not provide a legal fiction that it will be deemed to be in operation, then you cannot conduct an inquiry.
That's all.
My lord, that's all.
That is all.
The lordship will find this 11 para. Para 16, para 15.5, 16.4.
Yeah.
There it was referred to the SBI service rules, my lord.
Yeah.
My lord will kindly come. Therefore, the para 15.5. Therefore, the sanction sanctioning of cessation of service only for the purpose of the aforesaid rule. Clause 3 contains the clarification that if disciplinary proceeding has been initiated against such an officer under the relevant service rule before he ceases to be in the services of SBI, the disciplinary proceedings may be continued and conducted by the authority which had initiated the same even post cessation of service of the officer. However, he shall be deemed to be in service only for the purpose of continuance and conclusion of such proceedings and not for any other purpose. Now, kindly come to
It goes against you.
Against him.
my lord, kindly come to para 16.4. Kindly come to
16.4.
para 16.4.
Yeah.
My lord, sub-rule 3 of Rule 19 provides that in case disciplinary proceeding under the relevant rules of service has been initiated against an officer before he ceases to be in service of SBI by observation, operation of, or by virtue of any of the said rules or the provisions of the service rules, the disciplinary proceedings may at the discretion of the competent authority be continued and concluded by the authority by which the proceeding was initiated in the manner provided in the said rules. Post cessation of service, as if the officer continue be in service, but he shall be deemed to be in service only for the purpose of continuance and conclusion of such proceedings. Now, kindly come to para 31.
Yeah.
As has been held by this court on more than one occasion, a subsisting disciplinary proceeding, that is one initiated before superannuation of the delinquent officer, may be continued post superannuation by creating a legal fiction of continuance of service of the delinquent officer for the purpose of conclusion of the disciplinary proceedings. But no disciplinary proceeding can be initiated after the delinquent employee or officer retires from service or attaining the age of superannuation or after the extended period of service. Now, your lordship will see in this judgment, as far as I am understanding, that in the service rule there has to be a provision. So your lordship will see that.
With all due respect, your understanding is not correct.
Well, that is what I'm.
Due respect, please.
My lord, it may be, but what I am submitting is that in the service rule there has to be a provision, because if not, your lordship may. My argument is that.
Okay. That's all.
Yes, my lord.
This petition is filed by the petitioner. We agreed with the order dated 7th of April 2025. Issued by the Registrar of Vigilance of the Guwahati High Court, as well as the order dated as well as the communication dated 28/4/2025, issued by written by respondent number 4.
No, respondent number 5 it will be, my lord.
Respondent number 5.
Inquiry officer.
While order dated 7/4/2025, the Registrar of Vigilance of the Guwahati High Court has appointed the respondent number 5 as inquiry officer in the pending disciplinary proceedings against the petition. Stop. Wide communication dated 28/4/2025. The respondent number 5 has informed the respondent, the petitioner, to present before him on 17th of May 2025 in connection with the disciplinary proceedings pending against him. Full stop. The facts of the case are that the appellant, that the petitioner was the member of the Nagaland Judicial Services. What is the name of that services? What is the name of that services?
Nagaland Judicial, Your Lordship,
Nagaland,
Judicial Service Rule. Disciplinary
Judicial
appeal rule.
services, the Nagaland Judicial Services.
No, Your Lordship, Nagaland Disciplinary Service and Appeals Rule.
It's a appoint.
Nagaland Judicial Service,
Judicial
2006.
services.
2000.
Judicial services,
2006.
2006. Judicial services, that's all. Judicial services constituted under the.
It's judicial service.
Constituted under the Nagaland. Judicial services, while he was posted as principal and district judge. Principal and district judge, sir? Or
My lord-
district and session judge?
District and Session Judge Mon,
No. while
Sir,
he was
Dimapur.
posted-
Dimapur.
District and Session Judge Dimapur. He was appointed on 1/10/2021.
While he was working as district and session judge of Dimapur,
Dimapur.
he was placed under suspension by the order dated
14th.
Fourth.
My lord, it is
4/12/2024.
4/12, yes.
4/12/2024. On initiation of disciplinary proceedings against him. On 13th of January 2025. A charge sheet was issued.
Charge-sheet, statement of allegation along with witnesses and
Charge sheet along with the statement of allegations have been.
Statement of
has been
witness and-
issued.
list of document and
has
No,
been
statement of
issued.
witnesses were not annexed, my lord.
Evidence-
Statement of witness was not recorded also.
Okay, fine. Recorded, there is no question of recording unless the inquiry.
No, no, statement of witness, because that will come only once you carry out the inquiry.
Okay. Tell it. Have been issued to the petitioner, which was duly served, and pursuant to that, the petitioner has also
statement of defense here.
filed, has also filed
Defense
Is-
statement on 12 March.
on 12th of March 2025. Stop. Meanwhile, the Guwahati High Court, while exercising its powers under
Rule 22
Sub
of
Rule 2.
Nagaland Judicial Service Rule 2006.
Rule 20,
Rule 20, Sub Rule 2,
Sub-Rule 2 of the Nagaland Judicial Service Rules.
2006.
6 has compulsorily retired the petitioner from services on 31/3/2025. Full stop. Against which the petitioner has preferred a writ petition number
WPC 2278
WPC 2278
oblique 2005, 2025.
2025, which is pending consideration before this court. Full stop. However, the petitioner has assailed the letter dated 7/4/2025, annexure 1 and the communication dated 28/4/2025, sent by the assailed the letter dated 7/4/2025, issued issued by the Registrar Vigilance, whereby the respondent number 5 was appointed as inquiry officer and has also assailed the communication dated 28/4/2025, written by the respondent number 5,
No, respondent number 6, my lord.
the respondent number 6, to the petitioner to attend the disciplinary proceedings on 17th of May 2025 on the ground that once the petitioner is retired, compulsorily retired from the services, the disciplinary proceedings against him cannot be initiated or continued because there is no such provision under the Nagaland Service Disciplinary and Appeal Rules 1967 or under the Nagaland Judicial Services Rules 2006. Full stop. The facts, full stop. Learned counsel appearing for the respondent for the Guwahati High Court has opposed the writ petition on the ground that the disciplinary proceedings against the petitioner were initiated prior to his retirement, and the same can be continued as per the provisions of Central Civil Services in bracket Pension Rules 2021, which has been adopted by the state of Nagaland. Full stop. The facts which are not in dispute that the petitioner, a charge sheet was served upon the petitioner along with the memorandum of charges on 13th of January 2025. And the petitioner has also replied to this said, but along with the show cause notice, and the petitioner has also replied to the said show cause notice on 12th March 2025. Full stop. After later on, the petitioner was compulsorily retired from the services by the Guwahati High Court. On 31st of March 2025. Pursuant to as per Rule 20 in bracket 2 of the Nagal and Judicial Services 1967.
No, 2006, my lord.
2006, Anthony. 2006. Stop. The contention of the petitioner, the disciplinary proceedings against him cannot be initiated once he is retired from the services, is without any merit. It is settled that the disciplinary proceedings can be initiated. The disciplinary proceedings can be said to have commenced with the issuance of charge sheet C, Union of India versus KV Janki Raman, reported in 1990-14 SCC 109. Full stop. So far as regarding the question of continuance of the disciplinary proceedings against the petitioner after this retirement is concerned, it is to be noticed that the state of Nagaland has not framed any pension rules, and they have adopted the Central Civil Service Pension Rules 2021. Full stop. As per Rule 8 2A. A departmental proceedings, if instituted while the government servant was in service before his retirement, be deemed to be proceedings under the disciplinary rules and shall be continued and concluded by an authority deemed to deemed to be proceedings under the disciplinary rules. Full stop. Rule explanation to the rule. Explanation 1 in the bracket A. Explanation 1 in also is bracketed. A is also in bracket. Provides that the departmental proceedings against a employee shall be deemed to be instituted on the date on which the statement of charges is issued to the government servant, or and if the government servant has been placed under suspension, issued to the government servant. So, as stated earlier, the charge sheet along with the statement of charges have been issued to the petitioner through show cause notice dated 13th of January 2025. Hence, we don't find any merit in this writ petition. The same is therefore dismissed.
Obliged, my lord.
Item 12.
Malad, in this case, Malad, a guy on 362 will appear, Malad. In another code, Malad, he is in lakes, Malad. Maybe taken after some time, Malad, if possible.
From the map,
Yes, my lord, I was substituted, my lord, and I was tried by the summary.
this is person holding a fake identity
Yeah,
card.
I understand, but no evidence was adduced during the trial, summary court trial, man.
Being heard the land counsel for the party. Admit, no need to issue notice. Parties are represented. List in due course.
Item 13.
My lord, they have filed affidavit showing that there is an encroachment. There is an encroachment in the monumental area.
My lord, we have filed an affidavit, my lord. We are very clear in page,
60 bighas of land is in the occupation of the sericulture department.
no dispute.
Then when you are going to vacate it?
My lord, we will vacate it, my lord. My lord will pass a order, but the issue here is,
Pass a order, you have to vacate, sir.
my lord, the thing is that, my lord, is appreciate one thing, my lord. For the last 6 decades, my lord, we have been protecting that land, my lord. Now, just if we go, my lord,
As said,
my-
protecting the remedy is a state property. If you are protecting it, you are not obliged to anyone.
no, my lord. The
You are
thing
not
is
a
that,
private entity. You are the department of the state.
yes, my
If
lord.
you are protecting the state
My-
government
my lord,
land,
no,
what's the big deal in it?
My lord, what really we just want is that, my lord, let archaeology file that an affidavit that they are taking over the land, my lord. We have to give, just if we vacate it this moment, my lord, they are a private encroachers, my lord, they may come in. So that is what we'll just,
Hey, you are thinking about that. If the land is vacated by you, certainly the other department who is this archaeological department or whatever.
my lord will appreciate
they
one thing.
Take care of that.
Last 60 years, my lord, there has been a lot of private encroachment, my lord. Nobody came in, my lord. That is the thing, my lord.
Justification for you to remain in occupation.
We do not want to, that is why, my lord, We do not want to remain in a occupation, my lord.
So then why you are agitating?
We are not agitated, my lord. We want to hand it over, my lord, so that private entity doesn't come in, my lord. That is the thing, my lord. That's it, my
That's
lord.
right.
Only that respondent number two has to file their affidavit showing how they are going to protect the monument. If that is their duty, is there.
Lordship, in any case, if they are taking the,
Vacating the land, who will take care of that?
no, Lordship, the deputy commissioner is there. But
Is there-
there,
Mr. Chaudhary,
yes,
Mr. Chaudhary, who is the agency responsible for taking
Yes.
care of all these
the
old
archaeology,
monuments and all,
the archaeology will take it. over.
archaeological? So then why you are passing the
No,
buck to
no,
the
I'm not passing, Lordship. We have been taking it up with the deputy commissioner.
Huh?
We have been taking up the issue of encroachment with the deputy commissioner. In case this land is vacated, then we are going to take it over, Lordship.
So that is vacated, that's right. Now, they specifically, earlier they have admitted that if we are in occupation of this monuments land, we are obliged to vacate it.
Lordship,
Once they vacate, then who will take care of that?
Lordship, I'll file an affidavit giving a statement, we'll take over it.
Section 14, my lord,
We'll take over it, Lordship.
section 14 says it is their duty to protect
We'll
it.
take over it.
Not only sericulture department, there are
Absolutely.
private parties also. my lord.
Pursuant to the direction given by this court. On
127, only 60 vehicles. That's the
Yes, yes, private persons are there.
14 to 2025. The district commissioner Kachar has conducted a survey and demarcation
What is this?
proceedings and submitted a report along with submitted a report by whom this
The page 44, it shows private persons are also there.
and as per they said proceedings out of the 120 biga of out of around 120 biga of the land belonging to the monument का नाम क्या है इसका? What is the name of this monument?
Kash,
it is Rajbari
Kaspur.
Kachari ruins, my lord.
जी?
Rajbari
Kachari
Kachari
ruins.
ruins.
Rajbari,
Kachari ruins at Kashpur, my lord.
Kash-
Kashpur.
Rajbari, Rajbari,
Rajbari Kachari ruins.
Kachari
Ruins.
ruins
Page 37, it is there.
situated in
Kashpur.
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 Kashpur. 60 bigas of the land is currently under occupation of the sericulture department and falls within the boundary of the above referred ancient monument.
District.
Learned council appearing for the sericulture department has again frankly submitted that the land which is belonging to the monument and is under occupation of the sericulture department is required to be vacated. However, he raises a concern that after vacation of the land by the sericulture department, there is all possibility that some private persons may encroach over the land and therefore instructions be therefore the archaeological department be directed to take over the possession of the said vacated land. Because as per the which provision you are referring to?
Section 14 of the Ancient Monuments and Archaeological Sites and Remains Act.
Because as per
1950.
section 14 of the so and so act, the archaeological department is supposed to preserve
Maintain.
and secure the lands of old monuments. Full stop. Learned council appearing for the respondent number 2, place and time to complete his instructions and to file the same in the form of affidavit. List after.
My lord, may I just point out one? Like, besides the sericulture department, 5 other individuals are also in occupation of the land.
Let them first
But-
issue this SUV. Yes.
Like,
Item 14.
Lordship, in this case, we have already filed our affidavit.
In this case,
We have already filed our affidavit in opposition, reply, Lordship. And in that case also, the government of Assam has not filed any affidavit.
you are
Till the
for, you are for,
petitioner, Lordship.
you are for the petitioner.
Yes,
Yes,
Lordship.
sir, what is your reply?
They,
They
by
have
the,
already filed their response. The superintendent of police has filed his response.
yes, Lordship. But
No.
it is necessary to file affidavit in, affidavit.
Where is the?
Because I prayed before this honorable court to implement some of the laws as
Which
like
laws?
this,
Which laws?
as like Disha Act of the of Andhra Pradesh, Lordship, and Oparajita Act.
Madam, please. stand
Yes,
for this
yesterday also, 2 days back, Lordship, there is in some incident in Sribhumi
Very unfortunate.
jail, whereby
I'm
wherein
interested.
Lordship.
That's very unfortunate. But you can't, we can't direct the state government to implement the law of other states. Every state has its own problem.
And some guidelines is necessary, Lordship.
What guidelines, madam?
Lordship, kindly turn to page
Madam,
15.
madam, we have seen your reply filed in response to the affidavit filed by the.
It is by, yes, Lordship.
Madam, please hear us or you argue first. Either you hear us and or you argue.
Everywhere the ladies are, yes, Lordship.
No, you just argue it first. Then we'll pass an order. We'll not raise any
Lordship,
query. Will not raise any query, we'll pass it.
it is up to Lordship, Lordship. I am not arguing before this.
We are asking you something. You are saying that Telangana model which should be applied, Andhra model should be applied, this Calcutta model should be applied. When they have already said, okay, we have this mechanism in state of Assam, then why these other laws should be applied and those laws may be effective in those states, whether those would be say, effective as same here in this state. How can we issue such type of direction, ma'am? Can, adopt this law, adopt that law.
Lordship, kindly turn to page 15.
Read.
Page 15,
One
paragraph 15.
Yes.
That the humble petitioner state that the state of Karnataka Bhaji Naveen Khade Police versus Srivanna Tarkadi Srivanna in 2014, 8 SCC 913, the Honorable Supreme Court held that the fast track investigation and expeditious trial are the needs of the hour to control the rape crime in India. That by the order dated 3813, we had proposed to consider the matter on merit after service of notice to the accused respondent as well as a felt equally concerned as to why the Union of India should not take initiative and steps to evolve the procedure for fast track justice to be adopted by the investigating agencies and fast track courts by proposing amendments into CRPC for speedy justice to the victim. We had noted that the fast track courts no doubt are being constituted for expeditious disposal of the cases involving the charge of the rape at the trial stage. But we are perturbed and anguished to notice that although there are fast track courts for disposal of such cases, we do not yet have a fast track procedure for dealing with the cases of rape and gang rape laws under section 376 IPC, with the result that such heinous offences are repeatedly instituted. That further observed that there is a pressing need to introduce drastic amendments into the CRPC in the nature of the fast track procedure for fast track courts. Even we consider it just an appropriate to issue notice to and call upon the Union of India to file its response as to why it should not be should not take initiative and sincere steps for introducing necessary amendments in this CRPC 1970. Subsequently, that new amendment 2013 under BNS Act, Section 17, 70 of the BNSD, death penalty has been introduced by gang rape of women under 18 years of age. But not for other ladies above 18 years that of gang rape or murder in murder cases, Lordship. There should be some guidelines for that, for registration and investigation of the rape cases in Assam also.
Madam, this Telangana model, Andhra model, and West Bengal model on which you are relying. So in those cases, all the rape cases are now altogether stopped.
It is decreased, Lordship. In Andhra
Where is the
Pradesh,
data, madam?
I have stated in my petition, Lordship.
Decreased on account of this only after implementation of this.
Whether if the mindset is not
2024 law, and you are saying it has been decreased.
yes, Lordship. I have made
Calcutta,
statement.
It is decreased, that Arjigar case.
Yes, Lordship.
You are aware of that?
Yeah, I know. Operator Act is implemented thereafter, Lordship.
It is now just implemented.
Why, Lordship? It is difficult for the court, honorable court, to give a direction to the government, Lordship. I have mentioned some of the, what is the That is my prayer in page 19,
Yeah, read.
39, Lordship. To apprise the Honorable Guwahati High Court to the present status of rape crimes in the state of Assam along with the various stages of investigation, inquiry and trial of such crimes. To apprise the Honorable High Court to what strategy government of Assam has been taken to tackle rape-related crimes in the state of Assam and to status of such rape accused. The undertake pending investigation of the crime against women in a first-track manner, time-bound manner by forming special courts on similar lines as done under the POCSO Act. That the Honorable High Court may be pleased to form a committee to investigate the reason for increasing number of rape crimes in Assam and low rate of charge sheeting of Assam and suggest further measures to make Assam safer for women and children. The supplement implement the Supreme Court's order dated state of Karnataka versus Srivanna, Tarkadi Simandi 2014 8 SCC 9 in the state of Assam. Direct the government of Assam to bring laws similar to Andhra Pradesh Disai Act, criminal law 2019 in the state of Assam to effectively control the sexual offense against women and expeditious try such cases within death penalty. Direct the government of Assam to bring laws for introduce the punishment for compulsory castration of the
Castration, Madam, what is castration?
castration
Compulsory castration?
for accused of rape.
You mean to say that, okay, fine, it's a very strange thing.
No, then there is a judgment which was a commission. I must
Bizarre, how you can make such type of rates in PIL?
24 page 23, paragraph 24.
Read.
Page 23,
Page 23.
paragraph 24.
Yeah, what is it?
Married. That the petitioner beg to state the Madras High Court Judge Justice K. Kirubalan in this order dated 16/10/15 suggested castration of a child abuser as a punishment for a deterrent to rape-related crimes. This judgment was debated in a legal circle whose findings were as such following.
I'm sorry, we have no such, we don't want to have such, give some adventure or this type of, we don't have any courage to say.
It is up to lordship. That is,
yeah.
kindly see the now position of the, in paragraph 10 of my petition, I have specifically mentioned about that.
If I may be permitted, lordships, from the petitioner's own documents, page 45 of your lordship's brief. There, the whole premise of this petition is based on an assumption that there's a rise in the increase, there's a rise in of crimes against women. Page 45 of your lordship's brief, Assam has slipped from 5th position to the 7th position in 2021 and then to the 13th position in 2022.
But they don't deny that.
There is
there.
Yes.
You can't shy away.
I'm not shying away, but the petitioner's own document.
It is there, no
Yes.
doubt about
It has slipped.
These
Crimes
days,
against women has gone
unfortunately,
down.
everywhere it is going on. But
Paragraph 12, it is the Honorable Chief Minister Dr. Himanta Biswa Sharma who holds the charge of the Home Department in a question in Assam Assembly. He replied with a written answer that between 2016 to 2023, 12,726 incidents of rape have been reported in Assam, while 1,70,174 cases of crime against women have been reported. Of these, 39,700 were women-related kidnapping, 8,353 cases of murder, 103,296 cases of theft, 158 cases of dacoity, so and so. This is the report given in the Assam Assembly by the Honorable Chief Minister. It is not my version.
That's all. That's all.
Lordship, in this, some guidelines may be issued
Look here.
without perusal of the affidavit in opposition of the, filed by the government. Lordship,
This PL petition is filed by the petitioner seeking following prayers. The petitioner, while this PIL has raised a concern that the crime against the women, particularly rape cases, are on the rise in the state of Assam. And therefore, the state of Assam is required to take such some drastic steps for that purpose. Full stop. The petitioner has relied upon certain observations made by the Honorable Supreme Court and has also insisted in the writ petition as well as in the affidavit filed in reply to the response filed on behalf of the respondent number 3 that some of the schemes and the amendments made by the other states be also directed to be adopted by the state of Assam. Stop. The respondent number 3, in response to the writ petition, has filed a detailed affidavit detailing out the measures adopted by the state of Assam in consonance with its policy to maintain zero tolerance in crimes committed against women and children. The affidavit reads, the relevant portion of the affidavit reads as under page number 136, paragraph number 3. Page number 156 से शुरू होगा 150. As stated earlier, in reply to the affidavit filed on behalf of the respondent number 3, the petitioner has insisted that the schemes launched by the other states such as Andhra Pradesh, Telangana, and we also be directed to be adopted by the state government, state of Assam, and has also prayed that the amendment bill in the name of Aparajita Women and Child in bracket West Bengal Laws Amendment in bracket close Bill 2024 be also introduced in the state of Assam. Having heard the learned counsel for the petitioner and after going through the material available on record and after taking into consideration the rates sought for in writ petition, such as to direct the government of Assam to bring in laws to introduce the compulsory castration of individual involved in the crime of gang rape, in bracket all ages, comma, rape and murder, in bracket all ages, along with the rape of minors. We are of the view that the reliefs, we are of the view that the reliefs paid for in the PIL petition cannot be granted on the pleaded facts and the materials placed on record. Hence, we don't find any merit in this PIL petition. The same is therefore dismissed.
All right.
Item 15.
What about your portrait?
Tender is finalized.
My lord, in this case, my lord, letter of acceptance has been issued, my lord, by the department on 22nd of April, my lord, 25, giving 8 months time, my lord, for completion of the work. my lord.
Can be disposed lordship in view of the work order.
Legal, learned concept for the respondent, I informed that the tender for construction of the, what is the work?
Work, my lord,
What is the work, name of the work?
term has been given provision of roof, my lord, details given, my lord. Yeah.
Work,
Construction.
the details of the work.
Yes, sir.
What are the details?
Construction of RAB lordship. It is
Construction of?
RAB, road under bridge. Road under
road
bridge,
Under bridge.
RUB.
RUB.
Learned concept of the petitioner. The respondent has submitted that. For the construction of RUB as prayed in this PIL petition, the tender notice has already been, the tender proceedings have already been finalized, and Messrs. Keshav
Purkayastha.
Purkayastha Lumding is awarded tender for construction of the said RUB, and time limit for the completion of the said construction is given as
8 months.
8 months. A letter of acceptance dated 22/4/2025 is placed on record in view of the fact that the tender for construction of the RUB in question is already granted. We are of the view that no further orders required to be passed in this PIL petition. The same is for disposed of.
One more line may be added, lordship. Directing them to complete the work within the stipulated time, so that I will come.
Issue such directions. There are so many eventualities within the time, or may take some other time. That is for the authority to take
It is there, I'm submitting because it is their declaration that they are giving assurance it will be completed within 8 months.
Let us.
Item 16.
Yes.
My lord, we filed this writ appeal against the order passed in the IA.
For impleadment.
Yes.
Who is appearing for the other side?
But I am appearing for respondent 7-1.
Complaining.
And what about the other respondents? You are respondent number 7, the complainant. Who are you? What is your status? Respondent number 7 is the complainant.
No.
No, I think he is the anesthetist, my lord.
Anesthetist.
Doctor.
Doctor, I'm for 8.
You are for?
8.
8. So what do you want to say? What do you want to say? All the respondents are represented?
Yes, except 6 perhaps, my lord.
Who is the six?
The complainant notices have been served, but she has not appeared, it appears.
Okay. Notice upon all the respondents have been served. Having heard the learned counsel for the parties after going through the material available on record, we are of the view that the matter is admitted. After having heard the learned counsel for the party, the matter is admitted. List in due course, interim order passed by this court on 22/10/2024 is made absolute till final disposal of the issue.
Item 17.
May it please your lordship. Lordship, I am appearing on behalf of P. Mahanta, lordship. Lordship, my senior is not present due to some difficulty. Lordship, could the matter be fixed for admission hearing next week, lordship? If convenient, lordship.
Adjourn. September.
Item 18.
May I please, your lordship? Lordship, reply has not been filed, lordship, till date, lordship, by the
No,
respondent.
reply is filed, madam.
No, lordship, we have not received the copy, lordship.
No, it was filed on Mr. Chakravarti. This letter, this is 18. 18. Reply, yes, Mr. Who is appearing for that? This is a matter of dual pension.
Yes, lordship.
Mr.
Lordship, this matter is allotted to Mr. Adhikari, Lordship.
Why is not filing?
Lordship will give me some time, Lordship, to get it filed, Lordship.
Okay, Mr. Arjun Chaudhary. Previously put in appearing, estimate some time to file. Reply to the,
Lordship, maybe we give him short date, lordship.
reply to the restriction, list up to 2 weeks.
Lordship.
Item 24 to 38.
Yes.
That is, Lordship, I appear in item 24.
All these matters are similar, na?
Yes, Lordship, these are is from
You
the,
are appealing for Mr. Alda, you are appealing for all the respondents.
Not all, Lordship, though I have some respondents, I have appeared before the Honorable AFT, except one petitioner, Lordship, I have appeared in all the cases.
Here,
Yeah, in all the series matters, before the Honorable AFT, I have appeared, Lordship.
you
except-
appeared, but here you are appealing in some of the cases.
Yes, some of the cases, because Lordship, the situation in Manipur, most of the cases are from Manipur.
Okay.
And due to the ethnic violence and the post offices are also closed, they are from remote places. Even the telephonic conversation is also not.
Now, what do you suggest?
Now, Lordship, I have filed Wakalatnama in in item number 24.
You want some time? You want some time to be given to those persons to be represented here or what?
Lordship, that can be done. Lordship, I pray that, but Lordship, today this matters in item number 24. I have filed Wakalatnama and the reply also. Because of the matter is of pension, disability pension of the armed forces. So I pray that item number 24, then 36 and 37, 34, 36, 31, where I have filed Wakalatnama, that
But
can be
sir,
taken up today.
We have to hear all those persons also. If those notices have not been served to them since they are from Manipur,
No, Lordship, I am talking about the item number 24.
list after 6 weeks, we'll consider, let them wait.
List of the Lordship.
Is these matters for after 6 weeks?
No.
Item 39.
And yeah.
Item 40.
This one.
Your Lordship, this is for disability pension, Your Lordships. They were asked to file counter reply.
They have already
They have
filed the
filed this.
counter.
Please, Your Lordship. May I start? They say in their additional reply, Your Lordship, that the disability pension has been mentioned as mistakenly, Your Lord. If Your Lordships
What
may
they're
see,
saying, now they're claiming that original PPO, which you have received in 2021 or something date, where is that? Because they say
2021, Your Lord.
this is only this, which officer this? This is a calculation sheet
Page number
and not the
66.
PPO actually.
Please, Your. Now,
Not there.
now may I submit, Your Lordship? Your Lordship, PCDA is not the competent authority. The disability pension has been sanctioned by Air Headquarters. Your Lordships may refer to page number 63.
63? Yeah.
Please, Your Lord. 63 has been issued by Air Headquarters, which says, Your Lordship, disability pension with invalid pension. Para 2, may I read?
Yeah. In view of the above, the case of the grant of disability pension respect may kindly be proceeded as per the provisions of ministry so and so.
Please, Your Lordship. Also, they say that disability pension will be given if the disease is aggravated or attributable, Your Lordships. As per her medical certificate, Your Lordships, this disease is aggravated. Your Lordships may have her medical certificate as page number 60, Your Lordship, 60.
Yeah.
Annexure 13.
Madam, you do one thing.
Please.
What they're demanding that original PPO.
Yes, Lordship. That may be produced, Lordship.
There.
One party is with her,
Then only we'll consider it. Actually, it was ever sanctioned or not.
Even otherwise, if Your Lordships, if we go by the order passed by Learned Cat, Your Lordships, they have dismissed my petition only by saying that letter dated 2001 is outdated, Your Lordships.
It much water.
Your Lordship, even this is existing.
What do it mean?
Please,
It just shows that we'll do that.
please,
Then
this
we'll
is,
consider your argument.
this is existing as on date, Your Lordship. This is my submission.
Original PPO, because you are relying on a letter calculation that was already sanctioned. What they are saying, original PPO, there was no sanction for disability pension. Let us
Please,
see
please,
that.
I leave it to you.
CPL and council opinion from the petitioner waste some time to file counter to the counter affidavit.
There is nothing to file rejoinder, Your Lordships.
Place some time to place on record the original PPO received by the appellant on dated or on.
I'm so sorry. This covering letter forwarding of PPO letter is 17 December 2021, Your Lordships.
Original PPO.
Because the PPO does not have any date. It is not
Forwarded through, na? PPO was forwarded through.
forwarded by wide letter dated 17 December 2021.
PPO forwarded to the petitioner wide communication dated 17/12/2021.
Please, Your Lordships.
17/12/2021. Just after that.
Your Lordships may have it on 23rd of July. I am already here. Absolutely.
Just on 23rd of July as paid.
Obliged.
Item 41.
May it please your lordship. In this case, lordship, during a pendency of a writ petition, lordship, a point was raised by the learned single judge that the notification which was.
Yeah, that is there.
Lordship.
Violation of Assam regulations.
Yes, lordship, they have filed affidavit in opposition, lordship. As the appellate authority is Assam Land of Revenue Regulation, lordship. A second appellate authority was created by that notification, Lordship.
That
So
is
we
not
had,
permissible.
Lordship. And they have filed affidavit in opposition stating that, Lordship, they have already initiated process for, Lordship, ordinance was, they're going to create a act.
So
Lordship.
you mean to say that at that time when this order was passed, no, that authority has
No.
no jurisdiction?
Yes, Lordship. So may I pray, Lordship, as we have challenged the notification, Lordship, maybe it is hard by a single judge, Lordship. So can the, this,
Notification. Notification.
yes. As per their affidavit in opposition in page 156.
Let the, madam, will post it or the registry will check.
Lordship.
It is to be go before the single judge.
Lordship.
This
Then
will
the
be
both the writ petitions can be decided together, Lordship.
Yes, that 41 and 42?
No, Lordship, only this 41 and the point was raised from which writ petition, Lordship, that original writ petition.
Yes.
Lordship.
Now.
I'm deeply obliged, Lordship. I'm for only item 41, Lord. Obliged, Lordship.
Item 42.
You are from BSNL.
My lord.
Then these persons were not, the affected persons were not.
Lordship, they are no way affected person, Lordship, because petitioner was initially promoted on ad hoc basis, Lordship. Thereafter, his juniors were promoted on regular basis. Subsequently, petitioner was also, Lordship, promoted on regular basis, Lordship. Only the financial.
These directions, madam, their seniority is going to be affected.
No, Lordship, because only the pay scale will be affected, Lordship. It is between petition,
Will here matter requires some consideration.
Lordship.
Having heard the learned from the parties, we are of the view that matter requires consideration, hence admit. No need to issue notices, parties are represented. List in due course. However, till final disposal of this writ petition, the interim order passed by this court on 29/1/2025 shall remain in currency.
Lordship, I'm sorry, neither me and my friend were there on item 39 was called for.
Item number?
39. Lordship. Some urgencies, then a date may be fixed, Lordship, because they are pursuing the contempt, Lordship.
I have not received the copy of the IAS.
I will furnish him today itself, Lord.
You are not in talking terms with.